Back and we cross over to the corridors of justice, where the trial of the murder of lawyer Willie Kimani, his client and the taxi driver continues before High Court Judge Lady Justice Jessie Lesset. 4 police officers have been charged with the murder of the 3. Let's cross over there and listen.
But even if it's illegally obtained, you must also show that it's prejudicial. In this case, they are emphasizing that evidence is prejudicial. Of course, prosecution evidence is going to be prejudicial to the accused. Of course, as a matter of fact. The question is a question that you must answer in the positive, that is it prejudicial and is it also illegally obtained? You don't, the accused is trying to jump to the question that it is illegal by just claiming it is illegal. And the two must be linked. In this case, there is no evidence that evidence was illegally obtained. As I sit down, my lady, I just want to distinguish the authorities cited by the fifth accused. Briefly, take the case of Republic against Mark Lloyd Stevenson. In that case, the issue of the evidence being illegally obtained wasn't that the issue. So it's not an authority that applies here, because the fact the accused must first demonstrate that it is illegally obtained. So that authority doesn't help them. That the case of the second case that they also cited, the second case that they also cited does also not help them, because it falls in the same category of not really being it does also not help them because they have not demonstrated the pre-existing conditions that the evidence must both be illegally obtained and prejudicial. We apply that, we seek that you dismiss that objection so that this trial may proceed to secure justice for the victims, LSK and Kenyans. Thank you.
To reply, I seek 10 minutes. With regards to the submission, first of all, before my lady, as you've heard from our main submissions, our contention is that the evidence that is sought to be adduced is a confession hooded under this fanciful name of scene reconstruction. What constitutes a confession is ably laid down under Section 25 of the Evidence Act, and we submit that the conduct of the accused was and is a confession, and therefore the rules and regulations that necessarily and legally are required to be adhered to must have been adhered to before this evidence was admitted. With regards to the submission that this application is premature, this is an ungrounded attempt by the prosecution to further fetter the accused person's right. The court may recall that we raised this submission as soon as this evidence was sought to be adduced. With regards to the same and the submission that the court should consider the evidence and its veracity determined through cross-examination, we submit that this would be highly prejudicial, given that this evidence is inadmissible and therefore the court would be perpetuating an illegality. We are privy to this evidence by gist of Article 52J, and we have noted its prejudicial nature. And as officers of this court,
that is the Willie Kimani murder case that is currently underway. Our reporter will be giving